Data protection and privacy teams are under more pressure than ever with new laws, AI oversight, data breaches, and the constant expectation to do more with fewer resources.
That's why TrustArc built a modern privacy and data protection management platform powered by Arc Intelligence. It unifies your tools, automates the work that slows you down, and surfaces what matters most right when you need it.
From guided quick actions to our intelligent assistant, Ask Arc, you get credible, contextual answers backed by expert research, not generic AI guesses.
Finally, privacy that works the way privacy pros work.
Learn how TrustArc helps teams move faster with confidence at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.
Hello, and welcome to Serious Privacy. Today, I am pleased to bring you the recording of our latest webinar on Brexit, but particularly involving the points of view from the UK, the EU, and the US. We have three fantastic speakers for you today. First, my co-host, Paul Breitbarth from the EU. Then we have Ralph O'Brien, phenomenal senior privacy consultant from the UK. And on the US side, we have Josh Harris, our fantastic International Regulatory Affairs Director. I'm sure you will enjoy this, but please do make sure that you go to trustarc.com/resources, go to the on-demand webcast and register there. That registration will be your proof if you need to submit for CPEs, and of course, if there's ever documentation, we'll have it there as well. Take care, enjoy.
Good morning, good afternoon, good evening, wherever you may be, and welcome to the TrustArc Privacy Insights series. In today's program, we look forward to provide you with an update on Brexit from the EU, the US, and the UK perspective. My name is Paul Breitbarth, and I'm TrustArc's Director for EU Policy and Strategy. For those of you who don't know me, I come from the legacy Nimity side of the company. At Nimity, I also used to be Director for EU Strategy. I've been with Nimity for over 3.5 years, and before joining Nimity, I worked for almost 7 years with the Dutch Data Protection Authority. I'm joined today by two colleagues who will be here to share their perspectives on what is happening in Brexit. Josh Harris and Ralph O'Brien, who will each introduce themselves. Josh?
Hi, thanks everybody. My name is Josh Harris. I'm the Director for International Regulatory Affairs at TrustArc, and I will be chiming in at the end of the presentation to discuss the potential for US-UK data flows post-Brexit.
Ralph O'Brien, I'm TrustArc's Principal Consultant for Europe, based just outside London, where all the trouble started. So I'm here to talk about the UK perspective today. I've essentially going to be drawing on the 20 years of privacy experience that I have to speak and discuss with my colleagues surrounding the issues that Brexit brings up in terms of data protection.
Thank you both, and I look forward to our conversation. For today's program, as mentioned, we'll discuss the current state of play of Brexit, but we will mainly focus on what will happen next, both in the UK, between the UK and the European Union, but also between the United States and the United Kingdom. What will those relations be? What will it look like? And also, how can you prepare? But without much further ado, let's take a look at where we are with the UK and what is coming. On the 23rd of June 2016, 17,410,742 voters, or 51.89% of the persons who went to the polls, voted to leave the European Union. Let's get Brexit done, was the message ever since, and also Brexit means Brexit. And now it's here. Brexit has become a reality on the 31st of January 2020 at midnight Brussels time, and the UK has left the European Union. For the first time in history, a member state has left the European Union, has left the European Common Market. And whatever you think of it, and I'm sure that we all have our views on Brexit, it is a reality we have to deal with also from a data protection perspective. For now, it is good to realize we are in the so-called transition period. And the transition period means that the UK has indeed left the European Union, but in reality, nothing much has changed. All the rules, including GDPR, continue to apply until the 31st of December 2020, again, midnight in Brussels, which marks the end of the transition period. Officially, the transition period can be extended, but the UK has decided to rule this out as part of the European Union Withdrawal Act 2020, so there will likely not be any extension of the negotiating deadline. Ralph will discuss later what actually the UK intentions are for this new relationship that is under negotiation right now. The negotiations actually started yesterday. If we look at the meaning of this transition period and what is happening right now, we have to take a closer look at the revised political declaration from the 9th, which was closed between UK Prime Minister Boris Johnson and the European Union negotiating team. And if you look at it, you also note that data protection plays an important role in these negotiations on the future relationship between the European Union and the United Kingdom. Already in paragraph 8 of the revised political declaration, you'll find a note on data protection. And the parties are committed, as we can read, to ensure a high level of personal data protection. They endeavor to adopt decisions on potential adequacy for the United Kingdom by the end of 2020. And also the United Kingdom will, in the same timeframe, take steps to ensure the comparable facilitation of transfers of personal data to the European Union from the United Kingdom can continue to take place. But also it is clear that during the transition period, nothing really changes, although it does seem that the ICO, the UK Supervisory Authority, has stopped to take part in the meetings of the European Data Protection Board. So now we are negotiating the future partnership. We are negotiating what could possibly lead to an adequacy decision. So Ralph, what would you expect in the UK on possible deals? Will there indeed be an omnibus trade deal which covers all elements of trade, including data protection? Will there be a partial agreement? Will there not be an agreement in the end? What are the current expectations at the moment?
Well, I mean, I'm no fortune teller. I think that's the way I'd start. Anything can change in the next half an hour. And I think that would be what we'd caveat anything we say today, really, that anything can change up to and including, December the 31st, 2020. It's, of course, the government's intention to strike a trade deal on favourable terms. It is, of course, the EU's intention to strike a trade deal that doesn't give the UK the same level of advantages they had as a member state. That's always going to be, a difficult thing. It's not in the EU's interest to give the UK a good deal because they don't want other member states following suit. But equally, a close trading relationship to ensure that, trade is going to continue is in both parties' interests. Data protection, obviously the free flow of personal data. From the political declaration you have up on screen, the free flow of people's personal data is one of the key elements to ensure that trade can carry on as we would say in Europe, sans frontières. Even though politically we've already said that Northern Ireland will be sort of considered, essentially part of Ireland for data flows at the moment and for trade and customs. But the mainland of the United Kingdom, including, of course, Scotland and Wales, will be separate as far as trade and customs are concerned at the moment.
Ralph, you have prepared some slides also on the current legal framework in the UK and what will happen next.
Wonderful. Yes, thank you for that, Paul. So it's really important now that Paul's already laid out where we are today, and I think it's worth just taking a moment to look where we are today. And the current law in the UK is the UK Data Protection Act 2018. Now, this law came into force 24th of May 2018, so a day before the GDPR enforcement day, so to speak. And the goal of the UK Data Protection Act 2018 was to create a national law that repealed the previous Data Protection Act of 1998 and to align the UK with the General Data Protection Regulation. What we did was also to make sure that we also aligned with the EU Law Enforcement Directive. And EU, doesn't matter what country you are, isn't allowed to touch any member state's national security. So what we did in the UK with the Data Protection Act was to pass a law that looked at the GDPR and amended the GDPR, and then passed almost two separate privacy regimes, one for law enforcement and one for national security. And finally, of course, when the GDPR at sort of Articles 50 and above calls for a supervisory body and what powers that supervisory body has, we obviously had to write down in our law, our supervisory body is the ICO, and this is their powers. And equally, whilst the GDPR establishes liabilities on data controllers and data processors, it doesn't actually establish any liability on individuals. So the UK was pretty keen on establishing some personal liability criminal offences as well. So what that leaves us with is the current Data Protection Act from 2018. So if you like, part one is only introduction. Part two is what we would know as the GDPR. So what essentially it does is amends the GDPR. Now, the UK Data Protection Act is not worth reading in itself, because all it really does is say amend Article 2 like this, amend Article 3 like this, amend Article 5 like this. And really what it does is crosses out member states and writes UK. So where, for example, it says EU, it's like in places like EU representatives, you'll cross out the UK, the EU, and write the UK. And it creates what we call the applied EU GDPR. So if you're processing general personal data, the GDPR applies. However, if you're in law enforcement or doing national security or working for the intelligence services, we've actually created separate law enforcement regimes, separate protection regimes, if you like. And that will become very important when we start to apply for adequacy post-Brexit, because obviously our surveillance regime and our respect for individual human rights were one of the things looked at by the EU Commission as part of that adequacy journey. But for the moment, from the 24th of May 2018 to indeed the 31st of December, essentially we have the GDPR in the UK law via the UK Data Protection Act. So what we've done as part of the EU withdrawal Brexit situation is after December 31st, we will have this UK GDPR after the transition period. And again, that looks very much like the GDPR itself. However, we've made a number of amendments and caveats. And we'll talk about what those amendments and caveats are later. Perhaps the most important one as far as the UK is concerned is a number of exemptions in regards to immigration, a number of changes to the way the supervisory body works. For example, the ability to judge our own adequacy arrangements and our own data transfer arrangements without waiting for the European Commission. And wherever it says the EU or member state, changing that to the UK. So for example, where it would say EU representative, it now says UK representative, which means after GDPR, if you don't have a physical establishment in the UK but are monitoring or targeting services at the UK, you need a UK representative, much as right now you need a EU representative.
So it is likely in the future a lot harder, Ralph, if I understand correctly, because there is now the GDPR, the EU GDPR, there is the applied EU GDPR, and there is the UK GDPR, which all will apply to data sets collected at different times in different circumstances, but the applicability of those regimes will continue. So organizations will also really have to document properly what the legal regime was for data that they collected at a certain given moment in time.
I agree with that totally. However, I mean, one of the things about the GDPR is there is no sort of exemption for historical data. And that continues as far as the UK GDPR is concerned. So, you know, when the UK GDPR comes in, it almost doesn't matter how old the data is. The UK GDPR will apply. But I do agree it's important for organizations to have documented which rules applied and understand which rules applied, for example, on which date. The good things about this, as far as I'm concerned, is a lot of this is administrative. You know, it talks about representatives and international data transfers, but to a large extent, the GDPR remains the same. The principles are the same, the controller and processor obligations are the same, the data subject rights are the same. So organizations, apart from looking at things like international data flows and representatives, will largely be able to carry on. If you were compliant with the GDPR before, you'll be compliant with the GDPR afterwards. Of course, once the UK has left the EU, it's likely that the government will pass further legislation, either to consolidate either the two amended laws into one, or to pass another piece of data protection law at a later point. And I think it's at that point that it'll become very interesting in the future, and again, crystal ball gazing, how much at that point the UK exercises its powers to diverge from the current GDPR approach. So it's worth noting that the UK Data Protection Act does come with a load of criminal offences that are personal liability. So in addition to what we would previously see as what the GDPR applies to, which is only liability on a controller or processor to either have A, an administrative fine by the regulator, or B, the data subjects taking up a court case for damage or distress compensation. The UK Data Protection Act does bring a number of its own criminal offences. Unlawful obtaining of personal data without the consent of the controller, retaining personal data without consent of the data controller. These are offences we'd find put on, police officers who use the police national computer for other reasons than investigating criminals. You're looking up their daughter's boyfriends, that sort of thing. NHS workers, health workers who look up celebrities on health systems, this sort of stuff. One of the most interesting criminal offences in here is about re-identifying de-identified personal data. So if a data controller is deemed to make a data set anonymous, it's actually going to be a criminal offence in the UK to try and re-identify the individuals from that data set. We got what we call the offence of forced subject access, which is asking someone to do a subject access request in order to get a job, because we have the criminal records or the disclosure and barring service. We have alteration of personal data, so amending data you asked for on a subject access request, for example. If you amend data in order to avoid embarrassment or to avoid disclosure to the data subject, not even a corporate liability criminal offence, but a personal one. Obstructing the ICO, that's our regulator, trying to, or any sort of inspection by the ICO, making any disclosure that you're not allowed to do after our Investigatory Powers Act. That's our surveillance law, if you like, for law enforcement covert surveillance. So that's quite an interesting one when it comes to, again, adequacy, looking at our surveillance apparatus. Basically, there's a couple of offences which apply to the ICO themselves, but I think, again, for controllers, if the ICO comes to you and starts asking you for information, tries to execute a warrant to enter your premises, or even not registering with the ICO when you're required to, all these things are actually going to have personal liability, criminal conduct, and will continue to do so in the future. So moving on, what's the impact of all of these changes? And I think Brexit on data protection, I think this is where organizations need to begin looking. What's interesting, though, is even though the UK has left the European Union, we're still a member of the Council of Europe. Now, the Council of Europe is a 47 member state international organization. It's not an economic and political union like the EU is. But that actually keeps us subject to the European Convention on Human Rights, keeps the government subject to the European Court of Human Rights, and the UK has actually signed the Modernised Convention 108, which is an international treaty on privacy, and is duty bound to implement it. And what that actually means is that's actually going to make it very difficult for the government that wants to move away from human rights and that horrible EU human rights approach that was made much that's getting in their way. It's going to make it very hard for the government to move away from that, because they do have international obligations on human rights, which are actually plus points, very good points when it comes to looking at adequacy by the European Commission post-Brexit. Really importantly, as Paul said, the ICO is no longer sitting on the European Data Protection Board. The ICO, when we left Europe, actually ceased to be a European regulator ceased to be a European supervisory authority. Though they're still the UK's supervisory authority, it means that essentially they lost their powers of approval. So as we are aware, for international transfers and things like that, if you have had a binding corporate rule as an organization, if you have gone to the ICO and you've asked them to approve an ad hoc contract clause, if you've gone to the ICO and asked them to review certification or approve a code of conduct or a certification, their approval now doesn't matter. So any BCRs, any ad hoc contract clause, anything the ICO has approved, well, that's no longer a EU supervisory body approval. So what the European Data Protection Board has done is put out a notice saying that all organizations that have relied on, say, an approved BCR by the ICO should go to Europe, should find a new lead supervisory authority, wherever their sort of next biggest European presence is, and to get them reapproved. Now, you could consider this a paperwork exercising, but I'd be surprised how many organizations haven't realized that the ICO has lost its powers of approval, lost its GDPR powers of supervisory approval, and will need things reapproved by some new lead European supervisory authority. So, if you are a pan-national body, if you are operating outside of the UK into Europe, we really need to look at finding a new lead supervisory authority. So for now, we also retain this sort of EU, or later on in this year, the UK GDPR. Very similar laws apply. But from the 31st of December, what's going to become key is looking at international data transfer. As we know, the UK has already said any data transfer from UK to Europe, we will consider Europe adequate. We will consider Europe adequate. Feel free to export data as much as you like to the EU. We're going to consider that safe underneath our data protection regime. But the EU, understandably, haven't afforded us the same privilege. So the EU will have said, the UK is no longer a safe place. We are a third-party country, and there is this political establishment to try and get an adequacy agreement in place by the 31st December 2020. But of course, we have to consider what happens if that doesn't take place. What happens if we don't get to adequacy? What happens if there is a time gap? Even if we do receive adequacy, it happens after December. Then, of course, organizations will have to identify those data transfers where a data exporter from the UK to the EU and begin to document an alternative data transfer legitimization. Something like BCRs or standard contract clauses, or another one of those available under the GDPR. But for me, what's going to be fascinating is the future. So we can almost talk about now, we can talk about December the 31st, and we can talk about the future. Now, the future to me is where it becomes really interesting, because this is where we talk about the UK's political will to stand alone, to be independent, to legislate for itself. But of course, that means diverging from its EU partners. And the more it diverges from the EU, the more chances there is we become different. We become no longer a safe place or a safe harbour, and the rules will diverge, and therefore companies will have to operate different privacy regimes within their organisation, depending if they're in the UK or the EU. One of the key milestones for me will be the e-privacy regulation. Now, as we know, Croatia has released a new draft of the e-privacy regulation, but that could be the first moment of divergence. We have the old directive under our 2003 privacy and electronic communication regulations that governs cookies and electronic transfer and email marketing. But in the future, if the EU passes a new e-privacy regulation, will we follow suit? Will we pass something similar? Will that be the point of divergence? So to me, we can almost look at this Brexit impact in 3 stages. Now, everything stays the same, apart from the ICO is no longer an EU supervisory authority. 31st of December, Brexit. Do we have an adequacy agreement at that time? Do we have to look at third-party adequacy? And then the future. And the questions then become, how much will the UK diverge away from the current GDPR and EU fundamental human rights-based regime, and perhaps even look at adopting a different model, like US sectoral approach, or more of a commercial approach that looks at privacy not as a human right, but as a commercial commodity to be bought or sold. As I said, we don't have a crystal ball, but if we think about things now, December, and the future, I think the further out into the future we predict, the more changes we're going to see. But we are already seeing those changes, and that's what's really concerned me, is we're already seeing organizations like Google saying, actually, do you know what? Beforehand, the UK was in the EU. We're going to consider our EU Google users subject to European regulation. But as the UK left, Google was very quick to then say, we're actually changing our commercial agreements to make Google users in the UK no longer EU customers of Google Ireland, but instead customers of Google US. Now that's really interesting, because obviously, EU Google Ireland, you then got subject to the GDPR, subject to those enhanced privacy protections. But Google is already looking at users in the UK as being able to not be subject to those EU privacy laws, to be moved to the US model of the way their data is going to be dealt with, which could be considered to be less restrictive, more exploitative. So that's a fascinating development that's occurred already. We've already had political statements from Boris Johnson to say that how much are we going to diverge from data protection rules? As much as fundamental human rights, I believe personally, are really valuable to us, the government have said that, well, actually, they give individuals power and therefore reduce the government's power. And therefore the government wanting to self-rule, be more sovereign, pass more laws, be more in control of its own destiny, those pesky human rights get in the way. And therefore a reduction for those human rights can only be a good thing for the power of the government. But again, the more we diverge, the less chance we have of adequacy, the less chance we have of data sharing with the EU as we go forwards.
Thanks, Ralph. And indeed, the image, if you look at the headlines of what the future relation between the EU and the UK will be, could at some points be pretty bleak. I'm usually an optimist, so I still maintain that I do believe that there will be an adequacy decision by the end of the year, but a lot of water still has to flow through the Thames before we get there, or the North Sea, or whatever body of water you prefer. Let's take a look first at the EU perspective on these data flows. As I mentioned before, we currently have a Brexit with a deal, which a long time, of course, still was in the balance as well. And until the 31st of December of this year, we are in this transition period that we already discussed. But what will happen then? Will we see at the end of the transition period a deal where data is concerned, or will we see a no-deal scenario where the UK becomes a third country? If the UK becomes a third country, it is relatively straightforward, because that means that the data relationship will be the same as for any other third country that we see in Europe, like a China or a Russia, and that means that data transfers require a so-called data transfer mechanism. So in any case, you would need some contractual clauses, whether they are tailor-made or model clauses. Maybe binding corporate rules could work under some conditions. And of course, you need to pay careful attention when dealing with onward transfers. The onward transfer scenario will also continue to be relevant when there will be an adequacy decision. Of course, with an adequacy decision, data flows can continue unobstructed, and this will likely be a mutual adequacy decision, so that also data can flow from the UK to the European Union. And that is also the intended outcome of the negotiations that have started this week. If you look, however, at an adequacy decision, also then the onward transfers have to be taken into account. We saw that, for example, in the EU-Japan adequacy decision that was adopted in 2019. It could be that the EU will ask for some further commitments from the United Kingdom on how to deal with onward transfers to ensure that they will also maintain a proper level of data protection, like was the case for Japan. And of course, that could then, for example, be the case for data transfers from the UK to the US. We'll get more on that with Josh in a moment. So what is required when looking at a mutual adequacy decision? Well, first of all, GDPR, of course, explains in Article 45 that the Commission may decide that a third country ensures an adequate level of protection. That is more easily said than done. The Commission can, of course, just put out a paper and say, yes, we decide that the UK have their adequate level of protection because they have implemented GDPR. But usually it is not as straightforward as that, because the full legislative body of the third country will need to be assessed, the data protection regime, but also the oversight mechanism, further human rights legislation, but also laws that may impinge on the fundamental rights. I'll get to that in a moment. And then the European Commission will also need to monitor the functioning of the adequate decisions going forward. So even if the United Kingdom were to receive an adequacy decision later this year, that doesn't mean that they will have it for eternity, especially if the divergence that Ralph was talking about, if that divergence indeed is happening. It could very well mean that at some point the European Commission will have to withdraw the adequacy decision again. So adequacy this year is by no means legal certainty for all time to come. And rest assured, the European Union and especially the European DPAs will monitor the situation in the United Kingdom very closely to find out if the adequacy, if it is provided, will indeed be maintained. If we look at the negotiating guidelines that were adopted at the end of February, you can also see that it is indeed the intention to have an adequacy decision in place by the end of the year. The envisaged partnership, the new relation between the UK and the EU, should affirm the parties' commitment to ensure a high level of personal data protection, but also it says that it should fully respect the Union's personal data protection rules, including the Union's decision-making process as regards adequacy decision. And I'm speculating here because there is no explanation to what this sentence means. But in my opinion, it means that the European Union makes very clear that adequacy cannot be part of a larger trade deal. It is something that needs to be discussed separately, and it can't be a quid pro quo for better trade deals or a worse trade deal on either side. Data protection, being a fundamental right in the European Union, needs to be regarded as a fully separate negotiation. And that is also what we will see. If you look at the negotiating timelines, you won't see adequacy on there, at least not for the time being. What is needed for adequacy? Well, first of all the GDPR principles, the negotiating guidelines need to be respected. And also what is very relevant is the opinion of the European Data Protection Supervisor that was released on the 24th of February. And the EDPS makes very clear that when we negotiate adequacy from the EU, we need to include also the law enforcement authorities and the law enforcement sector. So adequacy for the UK cannot just look at commercial operations. It needs to include law enforcement as well, because that is an important element of the data flows between the EU and the UK. Ralph also mentioned it. And the EDPS also warned against lowering standards. It called upon the European Commission to keep monitoring. In between the lines, you can read that the messages that the UK Prime Minister has issued so far are not very reassuring on maintaining that level of personal data protection in the future. Finally, a final point from the EDPS opinion, but which is also included in the EU negotiating guidelines and also in the guidelines from the UK government, is that there needs to be a focus on specific security data, like DNA data, fingerprints, license plates, but also the passenger name records, so the flight manifestos of flights going from UK airports to EU airports and back, to make sure that also that data can continue to be shared. So that is part of the requirements for adequacy. But since Schrems, the Schrems 1 case in 2015, it is also clear that the term adequate level of protection must be understood as requiring the third country of having a legal framework in place that is essentially equivalent to that guaranteed within the European Union. And that is, of course, a whole different ballgame, because essentially equivalent is not just the data protection regime, but it also needs to include an assessment of any surveillance legislation. And we all know that the United Kingdom is part of the Five Eyes, that they do have surveillance legislation, like all countries have. But so far, the UK being in the European Union, that surveillance legislation was not relevant for personal data protection. and data flows, because it is outside the scope of what the European Union can legislate. However, now that the UK has become a third country, is outside of the Union, it is relevant and it will need to be assessed. Is there surveillance legislation in place? And if the surveillance legislation is in place, then how is it protected? Is there any way to ensure that any infringements on fundamental rights are limited to what is strictly necessary? If you look at the paper of the Article 29 Working Party on the European Essential Guarantees, also outlining all the case law related to data protection, you see a number of criteria that need to be taken into account when dealing with that assessment. Processing should be based on clear, precise, and accessible rules. There should be a demonstration of necessity and proportionality. There should be independent oversight and effective redress for the individual. And to be honest, I'm not that concerned when it comes to the United Kingdom about independent oversight and effective remedies. Also, the legislation is quite clear. It is the main question: does the European Union consider that this goes beyond what is necessary in a democratic society? Do they think the surveillance legislation goes too far, as some at least imply, or is it similar to what European member states are doing, and will it be accepted? And I think that will be a big driver in the forthcoming adequacy negotiations. And of course, we can't forget that there's also still a Schrems II decision pending before the European courts that may have an impact on the EU-UK relation as well, even though the Schrems case is about the United States.
I'll just add to that, Paul. On the point of the ICO, we talk about having effective access to remedy and rights, and the ICO as an effective regulator. I'd just be interested in your view as from an ex-EU regulator as to the harmony between the regulators. The ICO and indeed the Irish DPC has come under much criticism from other European regulators for perhaps being more business friendly than the other regulators, perhaps not taking the level of enforcement against companies that that might be expected of them. I'm just wondering what your views are, and will that become a factor in sort of a Brexit adequacy scenario?
It may certainly be part of the discussions. It could be part of the assessment of the European Data Protection Board that is required before an adequacy decision can be taken. You are right, there has been some criticism lately on the effectiveness of some of the supervisory authorities, namely of the Irish DPC, among others coming out of Hamburg. But I also note that the Information Commissioner's Office, and especially Commissioner Denham, have a lot of respect in the data protection community and also in the regulatory community. The ICO has always been a very active member of the Article 29 Working Party, also of the European Data Protection Board. And I also think that a lot of the DPAs regret that the ICO is no longer part of that family. Is no longer part of that group. So although there may be some criticism and there might be some pointers on where they think the ICO could or should do better, all in all, I do think that the general appreciation for the work of the ICO and their input in the international discussions on privacy and data protection will actually be prevailing, and making sure that this isn't too much of a negative factor going forward towards adequacy. I mentioned the US already, and that brings us to Josh. Josh, there is a lot going on between the UK and the EU, but earlier this week we also saw the opening, or at least the announcement of the opening, of the trade negotiations between the United States and the United Kingdom in parallel to the EU-UK relations. What will that have as an impact on data flows and data protection in your view?
Thank you very much, Paul. Well, I think probably the most important way to look at this going forward in terms of imagining the universe of data flows between the US and the UK going forward is to consider what this proposed UK-US negotiation actually looks like in the end. Yesterday, we saw the negotiating principles put out for this proposed negotiation by the UK government. When they talk specifically about digital trade, they talk about wanting to promote the free flow of information, maintaining the high data protection standards of the UK, making sure that whatever arrangement is agreed to is accessible across all sectors and sizes of participants in the economy. All of this points to a digital chapter, if in fact there would be a digital chapter included in this agreement, that could look very similar in structure to, for example, the US-Japan Digital Trade Agreement, or perhaps the digital chapter in the USMCA. There is language prohibiting unnecessary localization, the recognition of the different standards and making sure that the standards in each jurisdiction are respected. And then there's language, I believe, in the digital chapter for Japan that encourages interoperability, and then the USMCA encourages compatibility. Broadly, these would be the same two concepts. So then the question becomes, okay, what does interoperability or compatibility look like from a compliance perspective? And so there's a couple of ways to look at it. So the first way that you could look at it is leveraging Privacy Shield. Now, Privacy Shield, were it to be maintained and were there to be a positive adequacy determination, this would be the most straightforward kind of interoperability mechanism that you could imagine being contemplated in a potential digital services chapter. And in that instance, then, assuming again that this adequacy decision is made after or before the 31st December deadline, and that Privacy Shield is still standing, then you would see a continuation of that mechanism for U.S. businesses that want to continue to transfer data from the UK. Another possibility is that there is not a decision as to adequacy for the UK prior to that deadline, in which case the language on the Department of Commerce website right now says that there will have to be changes made to the privacy notices of those folks that are relying on data transfers from the UK to include that their Privacy Shield obligations extend to the UK. It's an open question, and I would turn it over to Ralph and Paul, conclusion of my presentation, as to whether or not Privacy Shield would still be available in the event of either no adequacy finding, negotiations are ongoing, or a negative adequacy.
I agree that in my understanding is that Privacy Shield is a EU-US arrangement, and therefore there would have to be some political agreement between the US and the UK to extend Privacy Shield to continue to apply.
Yep.
Yeah, that would also be my interpretation. I was actually surprised to read this guidance from the US Department of Commerce. It seems that they have unilaterally decided to expand the scope of the Privacy Shield to the United Kingdom, whereas the adequacy decision, well, you could argue that the adequacy decision from the Commission until the end of this year will also continue to apply. But what will happen after the 31st of December 2020? I would assume that any validity of the Privacy Shield would always require a decision from the UK government or the Information Commissioner's office to accept the Privacy Shield as a transfer mechanism.
Yes, that's my read of it. And then we can get into successively more complicated situations. I think the next one then would be that adequacy is achieved, but Privacy Shield is invalidated in some future court case. In that case, we're looking at a situation. Fortunately, we do have precedent for these types of situations, and that looks like a lot like the Japan adequacy determination that was made earlier, or actually 2 years ago now, a year and a half ago, that Paul had previously mentioned. When you're considering that situation, you're looking at specific onward transfer arrangements that would need to be applied to a third country. Those arrangements would apply to us, whether that would be SCCs or BCRs or whatever instruments might be available. Again, that's very speculative. And then finally, you get to a situation where there is no adequacy and there is no Privacy Shield, in which case you could go back to the beginning of the FTA that I was referencing and start to look at what other alternative mechanisms might be able to be developed between the US and the UK specifically. Whether or not this is some sort of an independent type transfer mechanism like a miniature Privacy Shield, or some sort of a cross recognition on certifications, some sort of an arrangement between just those two parties would then be probably the order of the day in that instance. But I know that there's a lot of moving parts to this, and it doesn't really give a very specific roadmap right now. But I think we will actually see a lot more as the next couple of months go on, and specifically as to whether or not we actually get an adequacy decision for the UK and how that would actually fit into our FTA.
Thanks, Josh. And yes, there are some questions on these points as well. So I'm sure we'll get back to that. I'm handing first to Ralph to advise a bit on the steps to take now. Being our lead consultant, that's your specialty, is giving advice, Ralph. So what should organizations start doing?
Yeah, thanks, Paul. Know yourself is my biggest answer. Know yourself. We already got obligations as an organization to carry out a data inventory or records of processing activity. You may just need to look at the EU now as, the EU and the UK, and then look at the import and export of data. So to me, it's where are you based? If you are based in the UK, the ICO may formally have been your EU supervisory authority. If you are processing data on people in the EU, covered by the territorial extent of the GDPR, you may have to look at an additional lead authority, i.e. report to two masters, the ICO in the UK, and also wherever your next biggest European site is, or wherever the majority of your data subject is, either establish a EU representative or establish a new lead authority within Europe. So number one, look at who your regulator is. It'll be the ICO in the UK, plus whoever your next biggest establishment is will determine your EU lead authority. Obviously, data transfers, we've talked a lot about data transfers today and what their legal basis for them are. Know what data remains here in the UK, know what data is being transferred from UK to the EU and vice versa, and indeed even out of the EU to the US and other organizations. And then look at the legal basis for those transfers. Make sure that you can still rely, for example, if you're relying on Privacy Shield from UK to the US, that's something that might want to be in review between now and December. When it comes to representatives, if you don't have a physical establishment in the EU as a UK company, you may now be required to have an EU representative, and vice versa. If after the transition period ends, if you're an EU company with no physical establishment in the UK, you may be required to have a UK representative as well. So look at that need for representatives in country. That's going to be a post-December piece of work. When you look at the risk, all of this is, of course, as we know, with any sort of legal compliance piece, it's all about risk management. Because let's face it, with Brexit, everybody is going to be caught out. Nobody is going to be compliant on day one. The regulators have stated, they're going to take some time to get themselves ready. So, enforcement priorities in the short term, do we see the regulators jumping up and down on people on January the 1st? Probably not. So look about this in regards to your other risk management strategies and make sure that you, look at this appropriately and proportionately to the rest of your business risks. What's going to be really apparent to your data subjects, however, your individuals you serve, is making sure that all of the privacy notices, making all of your records of processing are updated, making sure that individuals understand where their data lives, where it goes, when it moves to third parties, how it's protected. So privacy notice, records of processing, making sure they're updated, making sure the individual that we serve as an organization is put forefront in our minds and very clearly and transparently explained to what's happening to their data and how it's protected. And that's the point. That's the whole point of this, really. And we sometimes forget that. And the final point is data breach notification. Because you're now reporting to two masters potentially, that may actually give you two separate routes of data breach notification. If you are unlucky enough to have a data breach, it might mean that you're now answering to the ICO as a UK authority and the lead EU supervisory authority. So we really do need to consider data breach notification, identify who those lead authorities are, make sure we've captured our data transfers, and ultimately make sure that we're serving the individuals and protecting their privacy to the best we can be.
Thanks, Ralph. There's a lot of questions that we have received, so we'll try to answer as many as possible. Maybe there's quite a few that came in related to EU-UK data sharing and whether this is a transfer, what needs to be put in place, and how all this will work going forward. And yes, an EU-UK data transfer, data sharing will be a data transfer after the 31st of December of this year. Until the 31st of December, GDPR will apply as if nothing has changed. But as of 2021, also a transfer of personal data from the European Union, the EU 27, to the United Kingdom or vice versa will be a data transfer that will need to be regulated. What is required for that will depend on whether or not the UK will obtain their adequacy decision, whether there will be a mutual adequacy decision or not. If there is adequacy, of course, the data flows can continue without any change. If there is no adequacy, then standard contractual clauses or ad hoc clauses or binding corporate rules or other transfer mechanisms could be your way out. And binding corporate rules, of course, only if you are an international company with subsidiaries in multiple EU jurisdictions as well. Josh, one of the questions that came in for you is whether the UK might consider also joining the Asia-Pacific mechanism of cross-border privacy rules, whether that would be a possibility for transfers.
Well, I mean, obviously that's entirely dependent on the UK's prerogatives, but I would say that the structure of that system is designed to accommodate the regulatory requirements of the jurisdiction in which it's applying. So let's say that those baseline requirements around that certification are at 50. And then there's a careful analysis taken that says, okay, we want to actually implement the additional requirements under UK law, and those render out to an additional 50. It's entirely possible that the UK could structure their participation by adding on those additional requirements, thereby truing up the baseline level of that certification system with the requirements expected out of the UK. The one thing to note at this point, that system is only limited to participants in the Asia-Pacific Economic Cooperation, but I would note that the participating countries, 9 of them now, are in discussions to look at expansion paths, specifically to account for this kind of a situation, whether it's the UK or India or Brazil.
Possible, but politically unlikely is the way I'd summarize it. The UK is on a political mission at the moment to establish its own sovereignty and rule making. So to bring itself underneath another international regime, I would probably guess as politically unlikely, though certainly a possibility should we want to do so.
Okay. So following Brexit, will it create any issues or special compliance requirements if the company's data protection officer for a pan-European company is physically located in the UK? I don't think it is. There are also lots of examples of companies having their global DPO responsible as GDPR DPO, and I don't think that most data protection authorities are being difficult about that as long as they are registered. And we have seen, for example, a case in Hamburg a couple of weeks ago where a social media network was provided a fine of over €50,000 for not notifying that their EU DPO was based out of Dublin instead of in Hamburg itself. So notification of the DPO, yes. The location likely will not be a problem, but we have to see whether there will be updated guidance there or not. Also, some questions about lead DPO, about lead authority and how to deal with that, especially if your lead authority was the UK ICO. For that, also for brevity, I will refer you to the opinions of the Working Party 29 and the European Data Protection Board that provide much more clarity about all the criteria for how to determine what should be your supervisory authority in case of a change in circumstances relating to the main or single establishment. Any questions on the validity of the ICO guidance? ICO has, of course, provided a lot of guidance on GDPR. Ralph, what do you think? Will that guidance continue to be relevant also outside of the UK? Will it become less relevant? Will it all be changed? What will we see there?
Yeah, well, the ICO has actually been one of the most prolific providers of guidance, and I actually know that a lot of other data protection authorities will even point people to the ICO guidance because it's always been of high quality. Certainly the documented guidance on the website is the go-to for many organizations. So in the meantime, I don't see there's any reason that will change. The ICO's job is to promote compliance with the Data Protection Act 2018. That means issuing guidance. In fact, they've even got a statutory duty to issue some codes of practice under the Data Protection Act 2018, in addition to the GDPR. The only problem that will occur is if and when the data protection regime in the UK begins to diverge from that of Europe, in which case, obviously, their guidance will be less useful to wider members of the international community.
Okay, thank you. And one final question, and then we really need to wrap up because we are running out of time. A company headquartered in the United States using standard agreements, using the standard contractual clauses, do you expect that they will have to enter into separate data transfer agreements for UK data transfers with UK standard contractual clauses?
So again, standard contract clauses are approved by the European Commission. And we have talked already about the UK sort of grandfathering them as a way of being adequate when it comes to protecting data and international data transfers. But of course, anything ad hoc approved by the UK's ICO won't count anymore, any ad hoc, because they're no longer a EU lead supervisory authority. Any ad hoc contract clauses, any variations that they've approved locally will no longer be counted as an approved transfer mechanism for the EU supervisory authorities. But in regards to the UK, standard contract clauses remain to be a basis you can transfer data on. That will be grandfathered through. If they seek to diverge from that, or if they seek to adopt their own version, again, that's crystal ball gazing for the moment. And the other thing I'd add on that is we also have to look at the current Schrems case, which is seeking to invalidate standard contract clauses as, a lawyer paperwork exercise that doesn't actually result in protections for the individual. So I think the outcome of that EU court case will be very much look at the way SCCs are looked at in the future.
And with that, we have to wrap up our program.
That was some serious privacy. Thank y'all so much. So please look for us posting this on social media channels such as LinkedIn and Twitter. On Twitter, we are at Privacy Podcast. Also, look for us on your favorite podcast channels, whether that's Spotify, iTunes, any of the above. You can easily find us. You may also write us at seriousprivacy@trustarc.com. You can also find Paul or myself easily. We're both all over social media, very easy to find. And please remember, if you want to make sure you register so we have a record for your CPE credits, go to trustarc.com/resources and look for the on-demand webcast. Thank y'all, and we will see you next time.
If you're a data protection or privacy professional, you already know the pressure. Non-stop regulatory change, AI oversight, internal demands, and the expectation to somehow stay ahead of it all. And the old patchwork of tools just isn't cutting it anymore.
No. That's why TrustArc created a modern privacy management platform powered by Arc Intelligence. The TrustArc platform brings your workflows, evidence, research, tasks, and applications all together in one unified and intelligent workspace so you don't waste time digging, clicking, or context switching.
With Ask Arc, your privacy assistant, you can ask plain language questions about laws, jurisdictions, or even your own program data and get credible, cited answers based on NIMBY research and more than 1,000 global laws. It's explainable, transparent, and purpose-built for data protection and privacy.
So if you need to add a vendor, create a cookie banner, or start an assessment, quick actions take formally complex tasks, turn them into bite-sized guided workflows to save you time.
It's a platform that thinks like you, works like you, and helps you move faster with confidence, whether you're a seasoned DPO or you're just getting started.
See how modern privacy gets done. Explore Arc at trustarc.com/serious-privacy. That's trustarc.com/serious-privacy.